Oh,
Okay.
we got the notification.
Yeah, we know now.
Everyone on your best behavior, right? I like that it gives you the opportunity to continue or leave meeting at that point, right? Just in case.
Jordan and Marcy from the Utah Office of the Property Rights Ombudsman here today to talk to us about it, the 2021 legislative update. Jordan, Marcy.
Thank you, Jason. No, and we love the relationship we have with Jason and Brent and the trust. We appreciate the opportunity every year to come and number one, provide this legislative update. We're grateful for the opportunity and that the trust reaches out to us and is interested in hearing from us, and the other presentations we give. We really appreciate the opportunity. So with that, I know that every year there's a few new faces in these presentations, and so we like to take the opportunity to just briefly kind of introduce our office a little bit, let you know who we are, what we do, so that you know, as you're doing your daily work. I know there's a lot of government staff on here. I believe there's elected and appointed officials as well. Is that right, Jason, to your knowledge?
Yeah, we have some of those as well. Mm-hmm.
Yeah, so to that extent, right, our office is here as a resource both to private property owners as well as government entities. We're a neutral, nonpartisan state agency. We are government funded. We're housed in the Utah Department of Commerce. But otherwise, we're a neutral, nonpartisan agency that, in short, mediates property rights disputes. And we do that in a few different ways and in a few different areas, primarily in the areas of land use and development and eminent domain, right? So anything that relates or has or touches in some way takings law, the Fifth Amendment of the U.S. Constitution, or Article 1, Section 22 of the Utah State Constitution. And so, you know, on the eminent domain side, if a government entity needs land for a public purpose, whether that's a new road or a road widening or a public building of some sort, there's the recognition that sometimes that needs to happen, right? And so the legislature created our office to help the government entity know what their rights and obligations and duties are, and to also help the property owner know what their rights, obligations, and duties are in that type of a situation, in the situation where eminent domain is being exercised. And so a property owner can come to our office and request mediation. We can obtain a second appraisal for the property owner that the condemning entity pays for. The purpose being to help the parties have data points in determining what just compensation should be, right? What the government owes the property owner for the property that is being taken. And so we can get involved to help that process and try to work through that in a way that's going to be acceptable to all parties involved. And we spend a lot of time just answering questions. We also spend time mediating. So please, we get a lot of questions from local governments about, hey, you know, we need to do X, Y, and Z project. What role might eminent domain play in that? What are our obligations? What are best practices? Things like that. Please give us a call. We love talking to local officials and helping them understand those things. On the land use side, our primary dispute resolution tool is the advisory opinion. So we're going to be talking about land use today and a little bit about eminent domain as well. But on the land use side, if there's a dispute over how an ordinance should be interpreted related to a land use application, or whether or not the government is requiring too much through an exaction, a conditional use permit, is everyone following the rules? Again, a lot of the time we just have a lot of conversations day to day with people about those subjects. So please give us a call if you have questions about or just want to bounce ideas off us about what the law says or what the law holds in these kinds of situations. And then also either the government entity or a property owner, if they reach the point of a dispute where they're kind of at odds and they can't come to a conclusion, then one or the other party can request an advisory opinion from our office, and we can take an independent look at it and give a legal analysis of what a court might say in any given scenario. So again, that's kind of a general overview of our office. We also do a lot of trainings. We like to come to you guys and provide trainings that are useful to you and your communities. We recognize that land use is a local endeavor, right? And so each community is dealing with different growth issues, different development concerns. And we appreciate the opportunity to come to you and share what we know and what we can be useful in. I was just down in Hurricane City last week, learning about the issues that they're dealing with and trying to be helpful there. So please give us a call if we can be helpful in that regard.
And Jordan, if I could give a plug for those on-site trainings, I attended one with Jordan here a few months ago up in Cache County. I sit on a planning commission, and it was great. It was for this material that you think may not be the most exciting and and all of that.
Hey.
It was no offense. This was a great training.
He's not wrong. He's not wrong.
But it was something he does a great job in getting the information across. So it was kind of a land use 101, and what direction, what questions do you have? Anyway, sorry to jump in there, but I do have to give a thumbs up for Jordan and the team there and their training.
No, again, Jason, thanks for the endorsement. And yeah, please give us a call if we can be helpful in providing training. So with that, that brief introduction today, we have this legislative update for you guys, and we're focusing primarily on land use and eminent domain, the stuff that we do, right? So yeah, Marcy, go ahead and move to the next slide if you would. So this first one we have to talk about, and again, we'll try to leave time at the end for questions, but please do, if you have any questions, throw them out there, and Jason can jump in whenever he feels is appropriate. And we like things to be as interactive as possible. With some of these bills, we're still learning about them ourselves, but if we can provide any context or any information, we'll do our best. So this first one is pretty straightforward, and in listening to kind of the committee hearings on it, and I didn't have any direct involvement in it, but my understanding is essentially that there are a lot of implications to a county moving from one class to the next. We know there are different classes of counties. There's also different classes of cities, and we have a bill that briefly touches on that here in a moment, and some implications there. But with counties, it's all based upon population size, what category you fit in. And my understanding is that depending on what category you're in, you guys, county officials are going to know this better than I do, but there's a lot of implications related to taxation and what rules and laws apply to you. And I guess the situation right now is there's growth in Utah. If you guys haven't noticed, there's a lot of growing going on. And some counties are starting to push up against the limits of the county classification they're in. But the reality is they're just not ready to move to the next classification for a myriad of reasons. So there's a recognition at the legislature that a long-term solution needs to occur, but they're still working on one. So right now, the short-term solution that they've come up with is, hey, let's just move the numbers up so that the counties who are kind of pushing up against those numbers have a little bit more breathing room and a little bit more time before we can come up with a more long-term durable solution. So you can see how the numbers are moving, right? Counties of the first class are moving from a maximum of 700,000 to 1 million and up. And then it just kind of cascades down from there. Counties of the second class, third class, fourth class, the numbers have all just been adjusted up a little bit. While counties of the fifth and sixth class, they were not adjusted. So that's just something to be aware of, to know about, keep in mind. There's a little more breathing room there. And I think the take-home message is a long-term solution is in the works. So if you have ideas, I'd say contact your legislators. That's that one.
So I'll start off with a basic one as well. We'll sort of take turns going back and forth. So House Bill 17 is on utility permitting amendments. And basically it's a fairly simple amendment. It was promoted as something very preventative. as a way of preserving market choice and letting the market guide change rather than the government mandates. And basically it says you can't prohibit certain types of energy provided by a public utility. So you can't say, you know, in this county, we're not going to allow natural gas or something like that. You can offer incentives towards certain types of energy. But you can't outlaw it. And this was passed in response to a new trend in some of the West Coast communities to outlaw natural gas in new development. So sort of preventative and seen as a way of preserving market choice. So.
All right. So this next bill, this is kind of the big land use bill of the 2021 session. Every year, probably a lot of you are very familiar with what's called the Land Use Task Force. So it's basically an interim committee that was formed many, many years ago to try to help reach some consensus on land use law and what types of bills should be proposed at the legislature. My understanding is that leading up to the creation of the task force, there was just a lot of salvos that were being thrown across different bows, bills that would send messages, and it just got a little bit too much to the point where they said, hey, why don't we just get all the stakeholders involved at the table and try to come up with consensus legislation where everyone can say, hey, we're not getting everything we want, but it's something we can live with, right? Compromising. And so this is this year's land use task force bill, and the task force is composed of public entities as well as home builders, developers, realtors, the private sector. They come together and they try to come up with legislation that will improve land use law in Utah on balance. And so that was HB 409 this year, modifying certain parts of the Municipal and County Land Use and Development and Management Act, LUDMA, as we call it. So there's a few things that happen with this bill. The first thing we're going to talk about is that HB 409 establishes an annual training requirement for municipal and county planning commissions. So this is something that I think is a regular conversation at the task force is, hey, they're to the point, if you talk to someone on the task force, where they feel like they've got the rules pretty well calibrated. And there's a lot of rules in place that help communities to be able to pursue their goals while at the same time protecting property rights, striking that balance. But one of the more recent concerns that has come up is, hey, local communities really just in some regards don't have the resources to update their codes and keep them current with state law. And then, because of the turnover that tends to happen in local governments with elected and appointed officials, sometimes it's an education issue, and the local officials really don't know the law as well as they should when they're making decisions. So to pursue the goal of improving that, they said, hey, let's have some training requirements put in place. And so that's what they did. That's what this bill does. Go ahead, go back there, Marcy. So this section applies to first, second, third, and fourth class cities, right? So it's important to know what kind of a city you are. Fifth class cities of 5,000 or more if the city is located in a first, second, or third class county. It also applies to metro townships of 5,000 or more people, and it applies to first, second, and third class counties with a population of 5,000 or more in the unincorporated areas. So those are the communities that must comply with these training requirements. And what it does is it requires each member of the Planning Commission to complete at least 4 hours of annual land use training. And one of those hours is on general powers duties before the commission, powers and duties before the commission members participate in a public meeting. So that's kind of an interesting requirement, right? Is that you have to take that before you participate. I think I saw a question just come through. Dave Johnson's asking, will the state provide the training? Can cities that are not required still utilize the trainings? That's a great question. So what it does is it, as I understand it, the League of Cities and Towns, the Utah Association of Counties, they basically kind of identify training providers. Our office, we can provide 1 hour of training, right? So if you, like we mentioned at the beginning, if you want to call us out or have us to your communities. So in that regard, yes, as a state entity, we provide some of that training. I don't know for sure that they have identified all of the avenues for training, and there isn't a specific body that's tasked with providing all the training. Some of it can be from your staff, right? Your local communities can use staff to provide the trainings. And there's a lot of different entities out there. So I'd probably say contact the league or contact the Association of Counties to find out who's I guess authorized on the list to provide trainings. And then yes, anyone can utilize those trainings as I understand it. To that point, our office actually has a land use training fund that we're still kind of working the kinks out on. But local communities and training providers can reach out to us and say, hey, can you give us some grant money to provide some of these trainings? So if you're interested in that, want to learn more about it, please reach out to us. There's also a page on our website that talks about the Land Use Training Fund. And there are a lot of initiatives to try to bring this training at either low or no cost to these communities, especially considering now that it's going to be a requirement at the state level. And then the last thing there, it allows a commission member to count one of the hours by attending at least 12 planning commission meetings within a calendar year while serving as a commission member. So the idea is there that your experience is also training, right? So that's something to be aware of and keep in mind. The next part of HB 409, this is kind of a little tweak, but I'm interested to see where it goes. All it did was conditional use permits, right? There's always kind of there are often disagreements about what type of standards should be in place and what type of conditions can be imposed based upon those local standards. Disputes arise between an applicant and a local community, right? So everything in black here is existing language, right? In both the county and city LUDMAs. It says a municipality or county may adopt a land use ordinance that includes conditional uses and provisions for conditional uses that require compliance with, and then this was all that was added, objective standards set forth in an applicable ordinance. So I think the intent and the idea here is, hey, we want standards in place that if two people were to read them, they would produce predictable outcomes, right? Outcomes that everyone would reach. I recognize that that's sometimes hard, right? But I think that's the intent. And I think it also represents kind of a concern within the development community to be aware of that, hey, we want the standards to be ones that if I read them, I'll understand what they mean. So just keep that in mind as you're reviewing your conditional use standards. If you're looking at them and saying, hey, are these predictable? Are these standards that if anyone were to read them, it would produce consistent and predictable outcomes? Okay, this next one I think is a work in progress and may be changing soon based upon things I've heard from different stakeholders. But it's trying to address the concern related to vesting, right? So I think developers brought to the land use task force a concern saying, hey, we entitle these large master plan developments and we kind of scale our development according to rules that are in place when we get that development approved. But the problem is that years down the road, we're going and pulling building permits, and communities are looking at these building permits as new vesting events, right? Where they can say, hey, the rules have been updated, land use ordinances have been updated, you have to comply with these new rules. And in our experience, there's always small disputes over which rules apply, right? And so this provision was intended to try to provide more certainty there. So it added a provision saying, I'll just read it, for a period of 10 years after the day on which a subdivision plat is recorded, a municipality or county may not impose on a building permit applicant for a single family dwelling located within the subdivision any land use regulation that is enacted within 10 years after the day on which the subdivision plat is recorded. So the idea is that once the plat is recorded, that locks in for any building permits pulled related to that plat in a lot related to that plat. The local government can only apply the land use regulations that were in place when that plat was recorded, as long as 10 years hasn't elapsed, right? What about these new water efficiency standards? That's a good question. And that's why I think that this might be a work in progress, and I'll be interested to see how it plays out, right? Because number one, the stakeholders on both sides are saying, hey, this may have unintended consequences, just to the extent of record keeping, frankly, right? But then I think you're right. Grant points out that there's a lot of kind of nuances maybe that need to be worked out, and I don't think that the bill specifically addresses those questions, to be completely honest with you at this point.
And I think it puts a tough burden on particularly smaller communities to really keep track of what did your code say 10 years ago, or at the exact moment, or yeah, it's kind of tricky.
Yeah, so I attend the land use task force committee meetings, and everyone's agreed that, hey, this language wasn't what we really intended it to be, maybe, and so they're kind of revisiting things, and we'll see what they come out with in the next legislative session. But it is the law right now, and it's something to be aware of and to know about, especially if you have a question over vesting, right, and a dispute about what rules apply to a given provision or a given application. Another thing that, and to HB 409, what if land use regulation changes are in favor of the landowner, more allowances? I don't know of anything that prevents a property owner from voluntarily complying with new regulations, if everyone is on the same page about doing that. Okay, so next what it does, it articulates rules to govern development agreements. This, I think, is a welcome addition, right? LUDMA has always authorized local communities to use development agreements as a form of land use regulation and control, but that's all it did, right? Is it said, hey, communities, you can do development agreements. And so there's kind of a broad spectrum of how local communities utilize development agreements. And some recent cases came up in different communities that went to district court and one to an appellate court over kind of the scope and the applicability of development agreements, when you can and can't use them, how you can use them. And so, the stakeholders got together and said, hey, we should provide more clarity here. And so that's what this attempts to do, is it defines, number one, what a development agreement is. And then basically it says that if you're legislating, right, if you're making new rules of general applicability, or if you're doing something that isn't allowed by the current ordinance, essentially, then you need to treat it as a legislative act, and you need to approve it as you would an ordinance, right? So it has to go before the legislative body, and they have to enact or approve or execute the agreement. If it's an administrative act, if it's just subject to an existing ordinance and applying or establishing dates for something under an existing ordinance, then you can still do it administratively, right? What else it does is, if the development agreement doesn't specifically address a matter involving the development, the local ordinance or LUDMA applies. So the idea there being, where the agreement is silent, you look to LUDMA or you look to the local ordinance. That's just a clarification. And then it also says that the local government may not require a development agreement as the only option for developing land within the jurisdiction. So I think the idea and the intent there is that you have your ordinance, and someone can, quote unquote, by right develop under the ordinance, or they have the option to negotiate with the local community and potentially enter into a development agreement for more flexibility. So those are some of the major changes there. Looks like I have a few questions on that one. Is HB 409 retroactive? No, to my understanding, it's effective as of, I think it was May, don't quote me on this, May 10th. Someday in May, it became effective, and I'm not aware of any provisions that are specifically retroactive, but if you have specific questions about that, Andrew, feel free to give me a call and we can discuss it further. What if the development agreement establishes zoning? Again, that's the situation, right, where it's legislating. So you would need to put it through the process that you would put a land use regulation through, basically, and have the appropriate public meetings and hearings. If it legislates, you got to treat it as a legislative act, is the idea. Is it a land use or hearing is required? Right, exactly. That's my understanding, is that if you're gonna enter into a development agreement, you need to put it through the land use regulation process. So, okay, next thing 409 does, establishes certain roadway limitations. I won't go too heavily into this one for the sake of time, but low impact development, right? I think that was referred to earlier. If you're going to require it as a local government, then you can't require pavement widths of greater than 32 feet. The idea being that low impact development is more expensive. And so this is a way to potentially lower the costs and keep it affordable. And it accepts required vehicle turnaround areas, specific traffic flow constraints at intersections, and et cetera. And then it also, I think this is just to provide more flexibility. It says that a local government must, by ordinance, establish standards the municipality requires for fire vehicle access turnarounds on roadways. And those standards must be consistent with provisions of the state fire code. So instead of maybe in some ad hoc ways, involving the fire authority to say, hey, what should the turnaround be here? My understanding is this is basically saying, hey, do your work in advance and decide what you want your turnarounds to look like, and then by ordinance establish them as standards. So again, to me, that's a potentially a predictability and consistency scenario.
Hey, Jordan, do they define low impact development?
They do, yes. I'd have to go back and look at it, but there is a definition for what constitutes low impact development, I believe. Do you have any insight there, Marcy?
No, I was just wondering that if they left it just as it's up to each municipality.
No, they do. I think they did add a definition. I'd have to go back and review it, but it would be in the definition section of LUDMA and 102 there, I believe. So
we can look it up.
Yeah.
And you got one more 409.
Oh, okay. So yeah, so there's a lot going on here, and again, this is kind of a big one actually. So it modifies provisions related to property boundary adjustments and subdivision amendments. You guys are probably familiar with a lot of this. There's a lot of confusion and maybe some contradictions in state law about what constitutes a lot line adjustment, what is a parcel boundary adjustment. There you go. Thank you, Lyle. There's the other, yeah, it refers back to 1905 for the definition of low impact development. Perfect. Isn't LID related to stormwater runoff? How is that related to street width? My understanding is that it was just from a standpoint of cost, right? The low impact development is going to be more costly. And so if we're going to raise costs, then we should try to lower costs in other areas. I don't know that there may be, but to my knowledge, I don't know of any other further connection there. So that might be a question for someone else to answer better. So yeah, there's a lot of confusion about what constitutes a lot line adjustment, a parcel boundary adjustment, and when boundary line agreements should be used. So there's kind of those three different mechanisms, tools, and they kind of cross paths in some ways, and there's some confusion about when they should be used and when they shouldn't be used. There's been recent efforts to clarify different things related to each of those mechanisms, and LUDMA or HB 409 just kind of continues that process. And there's also an acknowledgement that it's ongoing. I know there's conversations between the Land Use Task Force and surveyors right now about ways to further improve and kind of tweak this area of the law to make it more responsive and useful and effective. But this iteration basically says that generally speaking, a lot line adjustment has to be carried out through the plat amendment process, while a parcel boundary adjustment doesn't, and is generally not subject to land use authority review. But it does specifically clarify that if you do something that causes the parcel to come out of compliance or go out of compliance with zoning, then the local government has the ability to deny permits on that parcel. So something to be careful of and aware of, and maybe you do even want to, as a property owner, get a preliminary review of your changes to make sure you're not going to run into issues down the road. And again, we'll probably see further tweaks in that area, but this is kind of an iterative process of improving that. And if you have specific questions about it, again, to me, this is one of those areas where, hey, let's talk about the situation you're dealing with and try to figure out specifically how the rules apply in that case. So. One more, prohibits a municipal or county land use appeal authority from hearing an appeal from the enactment of a land use regulation. This one's pretty straightforward. It just clarifies that the appeal authority is there to hear appeals of administrative decisions, not legislative enactments. Not really a new rule, just a clarification in statute. It's been, the case law has kind of always said this. If you want to appeal a legislative decision, you either do it at the ballot box, right, through referendum, or you go file a lawsuit in court. And typically after the enactment occurs, you have about 30 days to do that. But with administrative decisions, there is a local appeal process set forth, and that just kind of attempts to clarify that a little better. So I think that is the last, yes, the last one from 409. Back to you, Marcy.
409 really was sort of the big and meatiest of the legislative session. So I'm going to talk about House Bill 82 next. It's a single family housing modifications is its title, but really to me it really means basement apartments are now allowed. And it states internal accessory dwelling units, they're permitted in residential zones. And this really is my understanding. Went through 4 substitutions, it went through lots of compromises. They really listened to people and tried to make adjustments to keep the bulk of allowing apartments, but then give the local jurisdictions some teeth or some way to regulate to make it livable and workable. But the idea being we're seeing a huge housing shortage, and that if you can allow people to create basement apartments that can alleviate some of this housing pressure, but also allow maybe folks to stay in their family home by generating some income from it, or not leaving sort of this great empty space in your basement or other parts of your house. So now across the state, everywhere, internal accessory dwelling units are permitted in all residential zones. There's some exceptions here. So if I just said it's everywhere and across the state, what can we do? Can we regulate it at all? How can we adapt to this planning and zoning is really a local issue. How do we make it work at a local level instead of just one broad stroke across the state? So they have provided that you can exclude any residential zone up to 25% of the total area of the residential. So if you have 10,000 acres of residential areas, 25% of that, or 2,500, you can exclude it from this from the internal accessory dwelling unit ordinance. And if you're in a college town, so if you've got a college in your town of 10,000 people or more, you can exclude up to 67%. And my understanding is that's to kind of balance out just that tremendous pressure that some college towns have to house students, and just the real impact that makes on otherwise single family residential neighborhoods. Another one of the concerns was, what if people are putting in their basement apartments and turning them over to short-term rentals? First of all, that doesn't address the housing shortage. And second of all, that's a very different imposition on local communities. So you can prohibit short-term rentals, you can require licensing and permitting, and you can require that it be owner occupied, because there's a general feeling, experience that if the owner is living in half of the house, then they're going to choose tenants a little more wisely. Their tenants are going to act more like single family residential zone residents. I mean, keeping the hours or the noise levels or the activities and stuff. You also, you can regulate things like you can keep it from applying in lots in residential areas where lots are smaller than 6,000 feet. You can not permit it in mobile homes, things like that. What about any teeth to regulation? And the biggest thing, or you can file a lien of $100 a day fine for violations. So that's like if people start renting on a short-term basis, so less than 30 days, if they turn it into HomeAways or VRBOs or the like, $100 a day fine for violations. And you can file that lien, and it works much like a mechanic's lien. You go ahead and file it without a court process, but then you go to court in order to collect. So it's a little more of that threat sort of has some teeth to it. You also can record a notice that the owners must comply with local land use ordinances, and in particular, sort of the owner occupied and the long-term rentals only are the ones that sort of stand out to me as what you might want to alert homeowners to, just to really make sure they understand what it is they're getting into. So if you don't do anything, then come October 1st, in all of your residential areas, people can build internal accessory dwelling units, and I'll add their internal accessory dwelling units. They need to be part of the existing building footprint of the home. So this isn't a tiny home in your backyard. You can allow that if that's what you want, but that's separate. So this would only allow within the main body of the house. So if you want to have some regulation about this, you want to adopt your IADU ordinance to ensure compliance with any new regulations by October 1st of this year. So you'll want to be moving on that. And you'll want included in your ordinance whether or not you're going to exempt the 25% or the 67% if you're in a college town. If you want to exempt those certain residential zones. If you don't exempt certain areas, it's allowed everywhere. And then you want to update your short-term rental code and enforcement ordinance if that's something that you politically are interested in doing. And I'll note that if you don't pass your an accessory dwelling unit ordinance addressing these issues, people can go ahead and get started, and you later can do it, but they'll have non-conforming uses that are legal. So you wouldn't be able to stop them in the future if that's making sense. So if this is something that impacts you, I encourage you to adopt that ordinance by October 1st.
There's some good comments and questions in the chat on this one, Marcy. Just kind of going.
Read them. I don't see the comments since my screen's sharing.
Yeah, and so one person asked, does the 25% exclusion have to be within a single zone, or can you take 12.5% of one residential zone, 12.5% of another? I'll just say that's a great question, and we've had similar conversations without any definitive answers in the office here. We're wondering the same thing, to be honest with you. This bill, as probably a lot of you are aware, went through quite the journey to get to its final iteration. And I think whenever that happens, you come out with something that's a compromise, but we're always going to be able to identify question marks and maybe deficiencies or unclarities, right? If that's a word, lack of clarity in certain areas.
Agreed.
So yeah, I don't know that we have a really good answer for that question, to be honest. Another person said, is basement apartments a correct term? Internal units could also be include other non-base, and you address that, right? It is internal units, right?
It's internal. I mean, I didn't see anything that would prevent someone from, say, building a large addition and then later turning their large addition into an internal ADU. And I don't know
as long as it's all attached and kept within the primary building envelope, right?
Correct. There's some things that I feel it just doesn't address, and I'm assuming sort of future iterations will iron some of these things out.
And then Bill mentions college towns is problematic. It moves people from Provo to Springville or American Fork. The whole bill was problematic, really. Good point. Fair point. Well taken. Is the bill retroactive? Again, I don't know of a retroactivity clause in there or anything. If we were to allow the tiny house detached ADU in the backyard of a single family home, must the city also require an IADU on the same lot? Do you have any thoughts there, Marcy?
I don't believe it addresses that. I mean, certainly you could draft your local ordinance so that they could have either one. I don't think you could prevent them from building the IADU because of the way the state code's written, but I do believe you could prevent them from renting both.
Interesting. Yeah, and that's a good question to me, because I agree. I don't see anything in there saying that if you allow this, then you can deny an internal one. And the reality is that local ordinances under state law are interpreted to favor the property owner's desired use.
It's true.
So, you know, if you're owner occupied and renting both, that's a tough one. I think that one might need some more ironing out as well. What was our office's input on this legislation to the committee? Honestly, we really didn't. This one was, it came out and then it was just fast and furious, and right up to the end of the session, in my opinion. And I don't recall anyone ever reaching out to our office for input on this one. It didn't go through the land use task force. And that may be a reason as well, that it's a little more rough around the edges, to be honest, in some ways. Essentially eliminates, there's a comment that it essentially eliminates single family residential zoning in Utah. And then our esteemed colleague, Rick Plen, the other attorney in the office, he says, as to eternal units, for example, that would include garage conversions, in which case, okay, so he's just answering questions. Thanks, Rick. Okay, and then there's just a few more comments that everyone can see there. So HB 256, this one's pretty straightforward, and I think it's one of those ones that's related to a specific story, right? Legislation by anecdote, but it's probably an important thing to consider and to address. So what it does is it just simply makes unenforceable any clause within a development agreement between a county and a developer that requires a developer to solicit annexation into a municipality before obtaining permits or other development approvals. Again, I think the story went that there was a happening, it may have been in, well, I won't say where it was, but where a county basically entitled some land and then also included a provision in the development agreement that says, once you've pulled so many permits, you have to go request annexation into a nearby city. And that upset some cities. The idea being that, hey, county, if you're going to entitle lots and say that we're going to provide services to these lots, then you need to see that through to the end, right? You can't pass the buck on then to a local community and pass on the impact of those entitlements was the concern. So whether you disagree or agree, that was, I think, kind of the intent of this bill, was to say, oh, counties can't do that.
I'm going to run through 3 public meeting changes real fast. They're minor and they're really straightforward. The first is Senate Bill 72, Open and Public Meetings Amendments. And currently, you by law, you can't make any motions in closed meetings, including a motion to close the closed meeting and move to an open meeting. So now you, by statute, can take a vote to close the closed meeting. The next one is Senate Bill 125. And basically, as you all are aware, COVID really changed things. So a lot of meetings are held online now. And now we're sort of in this state of limbo where some things still happen online and other things are happening in person. And this stipulates if you're holding an electronic meeting, you need to have an anchor location where the public can attend in person. So it's fine to have the electronic component, but you need to have sort of an anchor location. So if folks want to do it the old-fashioned way, they can. If the building needs to be closed for health or safety reasons, that's okay though. And then the third thing is public notice amendments. And this is one that has really been needed. There's notice requirements, as you know, for legislative action and things. And a lot of communities don't have local newspapers that they can publish in. So this is a way where you can comply with public notice requirements by simply posting on the Utah Public Notice website. And they worked it out with the media. The media can get all these dates and all the updates for free from the public notice website. And it gives people one place to go to. And it doesn't change any of the dates or anything like that, I'll add. Okay, Jordan.
Thank you. So we may be entering the lightning round here shortly, but if you have any questions about these upcoming ones that we don't get to, please give us a call or reach out, email otherwise. This one was also a really hot topic in the legislature this past session. It started as HB 98 and had a lot more in it. But some things were kind of whittled down, taken out, related to timelines for building permits, potentially hiring third-party inspectors to do inspections. Those things came out. that second one largely came out because of a concern from FEMA, and that's why it went into special session and was ultimately passed as HB 1003. But in its final form, and from what I understand, some of those issues will probably be coming back to the legislature next year. So stay tuned and keep an eye on it if you're interested in those issues. What it ultimately came down with was it identifies what the requirements are for a building permit application. So related to timelines for approval of applications, there was some disagreement, is my understanding, often between communities and applicants about what constitutes a complete building permit application. And so this just clarifies what that is so that everyone can be on the same page about what a property owner or a developer needs to submit to have submitted a complete application. And then this is a big part, right? A lot of you probably are familiar with this and aware of what's going on here. It prohibits local governments from regulating certain building element designs of a 1 or 2 family dwelling. And so this was billed as a housing affordability issue, right? And also a property rights issue, that people should be able to kind of make the homes the way they want them to look, and if they want to reduce costs, and they shouldn't be subject to a 100% brick requirement or a certain percentage of rock requirement. So I think that was where the concerns came from, and you can see the lists of types of things that cannot be regulated. Again, I know there's talk of kind of further tweaking this one, maybe allowing certain historic districts or resort communities to have a little more flexibility and regulate certain things if they have a legitimate reason to pursue a certain look or feel in their communities. But that's where this one is currently at. So.
Okay, and I'll move quickly ahead to House Bill 171, Agricultural Land Use Regulation. And basically, as you know, in 2018, voters wanted to make medical marijuana, industrial hemp legal. And certain counties and municipal governments were trying to prohibit hemp in certain agricultural areas, and you no longer can. If the land is zoned for agriculture, then there's already some regulations in place about where hemp and things can be grown, and beyond that you can't restrict it, and it specifically states you can't regulate hemp production in conflict with state law.
So SB 164, housing affordability amendments. Not a lot to say about this one, but it is trying to address that issue, right? That everyone's grappling with. How can we make housing more affordable as prices continue to increase? And so this bill specifically provides a political subdivision may grant real property it owns to an entity for development as long as 20% of the housing are affordable units. And then it has a deed restriction requirement for 30 years. And then it also gives additional funding for other housing initiatives there. So that's really all I have to say about that one today.
Next, we're going to talk about regulation, Senate Bill 130, the regulation of concentrated animal feeding operations. And this has become sort of a contentious issue as residential communities grow and they bump up against agriculture. They're not as compatible as they could be. So if you want to restrict the siting of CAFOs, then you need to follow this statute. It's intended to give certainty both to the farmers and to developers and residents and to the government. Basically, if you're going to restrict the siting, then you must consider a list of factors. And it's things that would make sense, like distance from homes, hospitals, public areas, churches. And it doesn't say you need to find one way or another. It just says you need to consider it. And you can determine, because of the relative population density, that it makes the proper siting just not feasible. So it's not something you're going to have there. So the takeaway is, if you're going to restrict these sites, you want to follow the ordinances by February 1st of next year. And if you're not restricting them, then no action is required.
So this next one, HB 107, it kind of just addresses some concerns, as I understand it, that were raised by canal and ditch owners. As development grows outward, it runs into these historic ditches, some of them recorded, some of them unrecorded, potentially prescriptive easements. So it clarifies plats must reflect, quote, recorded easements for water and utility facilities as well as water conveyance facilities without a recorded easement where the developer has notice from the state engineer or a surveyor that the existence of the existence of the facility. So those all need to be reflected. And then it also requires some noticing to affected operators, right? Within 100 feet of the proposed plat area, and then also a timeline within which the local government has to allow any affected entities to potentially provide comment that the local government should then consider in their approval process.
And then well, no, I hear one more after this. The Housing and Transit Reinvestment Zone Act. It's a new development tool passed to spur investment in building housing around transit stations. I don't know if you noticed, but the housing shortage was a major push on this latest legislative session. And this one provides tax increments and other incentives to increase the density to force folks to go up within 1 mile of transit stations. So that really just affects the Wasatch Front right now, front runner stations, track stations. And it's seen a way of conserving water, improving air quality, improving access to employment by really making use of the hubs or sort of building nodes of higher density housing and mixed use development and the like around those front runner and track stations.
So this next one just kind of addresses as I understand it, a regional planning initiative or mechanism that affects some of your communities around the Point of the Mountain. There was the 15-member Point of the Mountain Development Commission created, and it played a role of kind of visioning, right? So it produced its regional vision for local communities, and now it was set, could you go to the next slide, Marcy? So it was set to sunset in July of 2021, but this bill just extends the life of that commission and kind of modifies or iterates its role to one from visioning to now coordinating and recommending. So it coordinates transportation implementation between those entities, including collaboration on local funding, as well as planning across jurisdictions, provides recommendations for funding infrastructure, and receives ongoing public input. So for those communities that have been interacting with that development commission, it's going to stick around a little longer, and its role is evolving a little bit. So be aware of that and know that's coming along.
So I assume we're trying to end by 11. So that's why I'm going through this so quickly. But House Bill 141, Municipal Service Amendments. This bill requires if you're annexing an area that you must first reimburse the service provider, the existing service provider, for the value of the facility if you're going to take over serving the customer. So like the electrical facilities, you need to compensate them for that. Way of keeping things fair.
HB 63, this one was something that everyone kind of already understood, but it came to light that the language wasn't very clear. So it clarified, right, that the cost of an impact fee study, the study that you conduct to determine what your impact fee facilities plan and impact fee analysis are going to look like, that can be included in the impact fee charged to developers and property owners on new development. So you can build that in to your impact fee so that everyone pays their proportionate share. That was non-controversial, just clarifying existing language, but it's a little bit more better language. So.
And then my last one's House Bill 115, Municipal Boundary Modifications. This is a consensus bill, and again, it adds certainty and transparency to both cross-county annexations and new incorporations. You guys might remember the hideout annexing part of Summit County last year, sort of some of the hurdles there or difficulties that they ran into and lack. And then similarly up in Weeder County when IRTA was incorporating. But so the first portion of it, cross-boundary annexation, it really creates a clear process. It requires a feasibility study be done. It allows transparency then, and then allows the affected county, they're required to either deny or accept the proposed annexation, but they can only deny under stated circumstances. So it really lays out sort of a very clear process and a clear mechanism by which to judge whether or not they're denying or accepting that. That adds some clarity. And then in incorporation, again, it creates more certainty. It sets forth an orderly process. They're required to give actual notice, which wasn't required prior to this. And there's an opportunity to opt out. You need permission to exclude certain areas. And really what it does, it makes really certain what clears folks are voting on. I guess in the past, there's been some confusion as to, wait, is this area annexed into this or over here, and different maps showing different things, and what if different scenarios happening, what happens here? And it really, it streamlines that, it gives it certainty, it sets forth the process, and makes it really clear what people are voting on. And it also requires a voter information pamphlet, which again gives that transparency and people certainty to know what exactly they're voting on.
Okay, so this one I thought was interesting, HB 83. We're running up against time here, but and you can kind of read through this, but basically there's a migratory bird production area. There was a 2-year window back 12 years ago when people could request designation. They've opened up a new window where people can request designation into that, and it provides certain protections, in my opinion, that are similar to like a agricultural protection area or something like that. And it also indicates that eminent domain may not be exercised to condemn land. This is the next slide, sorry. Land within a migratory bird protection area created before December 31st, 2020, but it provides exceptions, which you can read about there. So that's just something to be aware of if you are in those communities, primarily up along the Great Salt Lake, I believe. These last few bills did not pass, but we always like to look at bills that, hey, they kind of say something about something, right? So I won't go through them for lack of time, but if you want to look through, we can distribute these slides and share them, and you can look through these different bills, and if there's one you have questions about, let us know. But yes, thanks for having us. Again, we're always grateful for the opportunity to participate here, and we hope everyone has a great day. So thanks again for having us.
We thank you so much for giving this massive amount of information that we have. I know there may be some questions. I know we've pushed our limit on time. If you can stay around for a couple of minutes and maybe answer some questions.
Yeah, happy to stay a few minutes after if everyone's interested. I think people, well, yeah.
Yeah, folks, please type your questions into the chat box, and we'll try to keep that brief. I have one quick question as people are typing those in. Going back to the hemp production bill that was in there, is there a difference between medical cannabis and hemp production? Is that differentiated in that bill?
I don't believe it is. I actually had that exact same question as I was saying it. I don't believe so, but I know it's talked about as hemp, but then they bring up in the conversation that it was both. So I would need to go look it up for sure. I'm not sure if they just talked about hemp to make it palatable, or if it really only applies to hemp.
And could that be, so it's basically any agricultural zone, there's no restriction?
Locally, you can't. At a state level, they've put in some safeguards where it can't be grown within certain areas of, like, around schools and things like that. But a local level, you can enforce state law, but you can't say you can't grow hemp in this field. You can grow whatever else you're going to, but not hemp. If it's zoned for agriculture and you can grow other crops, you can grow, and it meets the requirements of existing state law, then you can grow the hemp.
Great. All right, I'm looking for questions here. One question is if we will be sending out the recording. Yes, we will be placing a copy of this recording up on our YouTube channel. Go to YouTube and search for Utah Local Governments Trust, and it will be the first one today. We'll post it up today, and you can also go into the playlist for all of our land use webinars there and see others that we've done in the past. It looks like that people must have run out of time, and so those are all the questions that we have. Thank you so much once again.
An hour of land use excitement tends to be just enough for people, you know.
Really
certain doses, right? It's good in certain doses. And just a reminder that the Ombudsman's office is there. They're available and they're very approachable, and you definitely can have your questions answered there if you prefer to do it through that as well. Thank you once again, Jordan, Marcy.
Thank you.
We'll close it out now.
Thanks for having us.
Bye-bye.